start with the 14th Amendment, because that's what this case is all about. The 14th Amendment was passed in 1866. It was ratified in 1868 in response to issues related to formerly enslaved Americans following the Civil War. It's pretty well accepted that its purpose was to take power away from the states. In fact, the Chief Justice noted this and questioned about this during oral argument. So that's the feeling. Article 1 and Article 2 have reshaped the relationship between the federal and state governments by requiring states to respect federal constitutional rights. And I think we might have the 14th Amendment in the chat box. But the real focus of this case and of what we're going to be talking about today is the third section, Section 3 of the 14th Amendment. And I'm going to read it to you and kind of emphasize the points that we're going to be discussing. So it says, no person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any state. Hold any office under the United States, who, having previously taken an oath as a member of Congress or as an officer of the United States. So we have a couple of phrases there: office under the United States, officer of the United States, or as a member of any state legislature or an executive or judicial officer of a state to support the Constitution of the United States, that is, they took an oath, shall have engaged in insurrection or rebellion. Shall have engaged in insurrection or rebellion. It doesn't say shall have been convicted of, it says shall have engaged in, against the same or given aid or comfort to the enemies. But Congress may, by a vote of 2/3 of each house, remove such disability. Okay, that's Section 3. Then we have another provision that's in play, Section 5, that says the Congress shall have power to enforce by appropriate legislation the provisions of this article. So we have this provision of Section 3, and we have cases that have gone into courts all over the country, a lot of them brought by voters that have held to be lacking standard. But the one that stuck was the Colorado case. And I'm going to be reading a lot of what the Colorado Supreme Court said in their 43-page, and when I say page, we're not talking nice, double space. We're talking pages with lots of words. 43-page majority by the 4 of them, and a dissent by 3 of the justices that span 25 pages. So this is quite a lot to unpack and to resolve as this puzzle is. So I'm going to be reading a lot to you. So we want to have a discussion, but actually a lot of it is going to be me really telling you what happened. And we are going to have points for questions. I'm going to take you through the 2 Colorado court rulings. I'm going to tell you what arguments Trump is making in the Supreme Court. We're going to talk about the Supreme Court argument, which is very, very instructive. And then I'm going to tell you how a court might proceed to analyze the case. We're going to have to do something with the Colorado case. The Supreme Court's going to have to agree with it, disagree with it based on its reasoning, or say it didn't have jurisdiction, or say whatever it did doesn't matter. So we're going to have to try to figure that out. So the case was brought, actually complaints were made to the Secretary of Colorado, Secretary of Voting, early September of this past year by Republican and unaffiliated electors petitioning the district court, asking the court to rule that Trump could not appear on the ballot. Trump and the Colorado Republican Party intervened, and the district court had a 5-day trial. It's expedited case management, and I'll talk to you about the Colorado procedure at some point, but there were deadlines, there was disclosure of expert reports, witness lists and exhibits, briefing and arguments on motions, and the trial court issued its ruling after that on a very expedited basis. So, fast forward. So the trial began on October 30th. These complaints were filed September 6th. The trial began October 30th. The evidentiary portion lasted 5 days, with closing arguments almost 2 weeks later. And Trump is participating, the Colorado Republican Party is participating. During those 2 weeks, the electors, the secretary, and Trump submitted proposed findings of fact and conclusions of law. The court issued a written final order on November 17, 102 pages. Now, granted, that was probably double spaced. This is the trial court. The trial court ruled, after taking in all the evidence, that President Trump had engaged in insurrection. It further concluded, however, that Section 3 doesn't apply to the president because he's not, and the presidency is not an office under the United States. And the specific rulings by the court, Judge Sarah Wallace, she said the 14th Amendment was ratified when it was insurrection likely referred to any public use of force or threat of force by a group of people to hinder or prevent the execution of law. And she found that what occurred on January 6th was the public use of threat or force by a group of people to prevent or hinder execution of the Constitution. So it met that bar, if you will. Then she said that Trump engaged in insurrection because incitement to insurrection met the 14th Amendment test of engaging in insurrection. She concluded that the acts of incitement and instigation were actions taken by those in a leadership role, and that here she believed that based upon the evidence that in fact that standard had been met. But then she said that office under the United States explicitly lists federal elected positions except the president and vice president. And she said that courts have traditionally found that exclusions were made intentionally. So the court found it's unpersuaded that the drafters intended to include the highest office in the catch-all phrase. So the court ordered Griswold to place Trump on the presidential primary ballot and certify it in accordance with her duties as the Secretary of the State because Section 3 didn't cover Trump. Okay, so the case comes to the Colorado Supreme Court, and it decides a number of things. I told you it's a very lengthy opinion, but at the beginning of the opinion, the court tells us what it holds. First, and I'm going to talk to you about the election code of Colorado. It's a very expedited procedure, and one of the dissents takes issue with this. It's a very expedited procedure. But the Colorado Supreme Court said, hey, the election code allows the electors to challenge his status as a qualified candidate. And if he's not qualified under the Constitution, then he's not qualified. The state has the power to determine that. In fact, it's cited, interestingly, from a case written by Justice Gorsuch when he was a judge, saying the states do have the power to determine qualifications for office. It was a distinguishable case, but it's kind of interesting that they plugged that in there. And they said that there's sufficient due process under the election code of Colorado. Secondly, it said Congress does not need to pass implementing legislation for Section 3's disqualification provision. It is self-executing. We'll get into this later because one of the dissents takes issue with that, this whole idea of self-executing and whether Congress under Section 5 has to enact something in order for Section 3 to be operative. It's a big issue. Third, judicial review of the eligibility is not precluded by the political question doctrine. Some situations where there are not manageable standards, the court, and sometimes they say when they really want to avoid discussing something or deciding something, oh, it's a political question. It was not a political question according to Colorado. Then they said, well, district court, our trial court was wrong about the office of the presidency. And in fact, the president is covered by by Section 3. He's taken the oath of office as president. And there's reversible error by this because he is indeed covered. So then it said the district court didn't abuse its discretion in admitting portions of Congress's January 6th report in evidence. Abuse its discretion is a standard of review that we apply, usually having to do with the admission of evidence. And it found the court had not abused its discretion. Then it addresses the whole concept of insurrection, saying that the court didn't err in concluding that it was an insurrection. And it concluded that the court didn't err in concluding that the president had, quote, engaged in that insurrection through his personal actions. Lastly, it held that President Trump's speech inciting the crowd that breached the Capitol on January 6th was not protected by the First Amendment because it was likely to produce imminent lawless action. And as you know, you can't yell fire in a crowded movie. You can't incite to imminent action. So that's what it held. And it said this at the very beginning. But then it also said, you know we travel in uncharted territory. And this case presents several issues of first impression. So they're going to stay their ruling until January 4th. In other words, Trump will remain on the ballot unless the case goes to the Supreme Court, which they knew it obviously would. So we have the ruling, but Trump is still on the ballot in Colorado. Now, having said that, Colorado has a primary on March 5th. So I've got to be thinking that people in Colorado are getting a little anxious to whether this is what's going to happen. And it wouldn't surprise me, a la Bruce's question about, whether an opinion is already written. And we'll talk a little about that when I talk about the argument in the Supreme Court. There are opinions being written. I wouldn't be surprised if it comes out any day now. In fact, I was wondering, what if it came out today? I'd be a little bit preempted, but I think probably next week we'll hear something because they're just not going to keep Colorado on the edge of their seats waiting because there is a primary scheduled, and as far as we know, it's going to take place. So that's what the Colorado Supreme Court majority said. And I must tell you that all of the justices on the Colorado Supreme Court were appointed by Democratic governors. What happens is there's an appointment process where they serve for 2 years, and then they have to run for election. And all of them, other than one of the dissenters, has had that election. The election really is a retention election, and they will have a 10-year term if they satisfy that retention election. So we have 4 justices agreeing with what I've just said. And then we have 3 justices who disagree with certain aspects. And it's kind of limited what they're disagreeing with. Of all of those issues, the only disagreement has to do with the process, the Colorado process that is used under the election code, and the question of whether Congress needed to act under Section 5 in order for a procedure to be adopted. So we have Chief Justice Boatwright, who believes that the whole challenge is incompatible with, the code is incompatible with this process. There's breakneck speed under the Colorado election code. The challenge has to provide notice in a summary matter that gives rise to the complaint no later than 5 days after the challenge is filed. A hearing must be held. Well, that's okay if you're challenging the residency or the age or whatever, but this is a complex matter. Certainly this election code provision is not what it should be used for this kind of a complex matter. Then under the code, the district court is to issue findings of fact and conclusions of law no later than 48 hours after the hearing. Well, you're really going to do this in an insurrection case? And as evidence that you really aren't going to do that, the trial court in this case didn't do it. I mean, do it really speedy, but couldn't do that. And I must tell you, I told you the trial started on October 30th. Well, the Supreme Court in Colorado heard argument in the case on the 6th of December, and they had 12 amicus briefs. There was fully briefed, heard argument, issued this huge opinion on December 19th. December 19th. And it really makes for interesting reading. Not that you'll have the time or want to do it, but it really is quite. And at some point, I'm going to congratulate the Colorado Supreme Court on this amazing process and the speed with which they did it. So the next dissent really talked about procedural due process as well. The fact that these proceedings, which lack basic discovery, the ability to subpoena documents and compel witnesses, to adjudicate a federal constitutional claim, it just can't be. But this particular judge, Justice Samora, said that the real problem here is that the states are not free to apply their own procedures to enforce Section 3. He says that is hard for me to swallow, the argument that the states can do this. And he says that this is the most concerning misstep in the lengthy opinion, and he's focusing on this analysis. So he immediately starts with a case that, if you listen to the Supreme Court argument, it was mentioned a lot, and it's going to feature a lot, I think, in the opinion, a case called Griffin's case. And it was decided by Chief Justice Samuel Chase, but not when he was acting as a Supreme Court justice. He was sitting as a circuit court judge. It was decided in 1869, a year after the amendment was ratified. And in that case, Mr. Griffin had been convicted of assault with intent to kill by Judge Sheffey. And Judge Sheffey had sentenced him to 2 years imprisonment. Well, Judge Sheffey had taken an oath to support the Constitution, but then he served in the Confederate legislature of Virginia. So Griffin, after getting convicted, says, aha, I think that I have a way here of undoing Judge Sheffey, getting him declared not a judge, and then vacate my conviction. And sure enough, he said the day of its promulgation, it vacated all offices held by persons within the category of prohibition. So Chief Justice Chase says, well, that's really a nice try, Mr. Griffin. But, the context in which the disqualification clause was enacted says that, Congress is really the one that has to decide this. And Congress has not enacted something. So until Congress does, there are considerable procedural and normative mechanisms would need to be introduced. Certainly, proceedings are indispensable. And he said, Chief Justice Chase, these proceedings can only be provided for by Congress. So we have a justice back then. It's not really a precedential decision. There are non-presidential rulings and presidential rulings. It wasn't decided by him as a Supreme Court justice, sitting as a Supreme Court justice. But, it's something said by a pretty important judge a year after the amendment was ratified. So the dissent says, listen, I take it from Griffin's case that we really don't have a situation where a state can declare someone disqualified in this way because Congress has not acted. The dissent goes on to try to harmonize some other aspects of the case, but concludes when a party wishes to assert its Fourth Amendment rights offensively, and that's what was done here. Griffin came in and said, aha, then it must bring a cause of action under legislation enacted. And more evidence that this is what Congress is supposed to do, not the states. Congress enacted an Enforcement Act of 1870 designed to have a quo warranto mechanism so a civil suit could be brought to remove from office a person who was disqualified by Section 3. So certainly doesn't this say that Congress thought it had this power? Now, it is true that law was later repealed. But what ends up still being in effect, and some say was really what's left of the Enforcement Act, is a criminal provision under 18 U.S.C. 2383 for insurrection. And it says, whoever incites, sets on foot, insists, engages in any rebellion or insurrection against the authority of the United States or the laws, or gives aid or comfort, shall be fined under this title or imprisoned not more than 10 years or both, and shall be incapable of holding any office under the United States. So kind of that's, the number 3. You've got Chase, you've got the enactment, then you've got, we've got an insurrection provision, we've got a crime, and that's what's left of the enactment, and you can't hold office if you're convicted of it. So if that isn't evidence of it, I don't know what is. So that was a very interesting dissent for sure. And I think the last dissenter actually talked also about the election code and how this really isn't what should be used for a complex case like this. So fast forward, and Donald Trump wants to come to the Supreme Court. So what does he argue? He picked his issues. You don't come to court and say, I'm going to throw everything against the wall. It won't stick. And the things that you want to stick will probably not, because you're arguing too many things. And we find that in our court, but specifically in the Supreme Court, you got to pick your arguments. So he argued that he's not an officer. He argued that didn't engage in insurrection, said that the Colorado trial court imputed the conduct of others to him, didn't really talk about anything particular or directed at any illegal content. Now, I take issue with that finding. When you look at findings of fact as found by a trial court as to what happened, unless there's clear error, they must stick on appeal. And we'll see in the Supreme Court argument where they note that. So the fact of what the president did or didn't do is pretty well documented by the Colorado lower court, the trial court. And when it came to the Colorado Supreme Court, they spent a lot of time going through exactly what happened and going through specifically comments at that right there, addressing the crowd on January 6th, citing tweets, citing things that were said. So that's a little bit, I think, difficult to fight, but it still could be fought. They could also redefine insurrection and make it be viewed, a little bit more difficult to prove, have it be much more on a large scale rather than just what seems like at common law, fairly low standard. He argued Griffin's case, that Section 3 is not self-executing. Congress has to enact legislation. And then he argued, came up with a principle of federalism. And there's a case called U.S. Term Limits versus Thornton, decided by Justice Stevens. And it basically said that the people of a single state cannot prescribe qualifications for president. And there's something appealing about federalism. It strikes a chord with the Supreme Court very often, and it's a very good argument that, and I don't think in the Colorado court federalism was really mentioned that much. Another thing that Trump mentioned, but I don't think is going to matter, the Section 3 talks about holding office. Well, Donald Trump doesn't hold office yet. is this premature? And there's a provision that Congress can undo it. So what are we doing here? Why are we doing this? We really need to wait till he's the president. Well, I don't think that's going to get much traction. We'll talk about that, but all of this process, and then the Supreme Court says, not right. We'll see you later. Come back to us when he's the president. The other thing that he didn't do in the Supreme Court is go after the Colorado procedure. Now ask yourself, why didn't he go after the Colorado procedure? Because it wouldn't get him anywhere. He'd be back in another state, in another procedure. He'd be back in state court with a different procedure than the election code. It doesn't get him there. And his lawyer said that during the argument. As big a deal as it was in Colorado, it doesn't get him home free. If the Supreme Court were to say, the process wasn't sufficient, it's too complex, then sure enough, there's going to be a case filed where they have all the discovery they want, all the subpoena power, you name it, and he's back in court. So he, that wasn't something that was appealing, shall we say, appealing to him. I got the transcript, I poured through it. I was actually hearing cases on the Court of Appeals when the argument was going on. So right away, Clarence Thomas asks about self-executing and Griffin's case, and the importance of Griffin's case. Justice Sotomayor, excuse me, pushes back. She spars with him that this was an NPO. There was a later case involving Jefferson Davis where Chase did something different, but that case can be distinguished and discounted. So then Mr. Mitchell, Trump's attorney, says, well, then we've got the Enforcement Act. So we've got that. So Justice Kagan, excuse me, chimes in and says, oh, so we have Griffin's case and congressional action that might be kind of like preemption. Well, she is alerting the other justices to, and Justice Sotomayor, that this isn't just Justice Chase, there's more here. Then Justice Barrett chimes in with the concept of terms limit versus Thornton. The state can't add qualifications for federal office. And Sotomayor is still pushing back. And Mr. Mitchell, she doesn't understand why this really is state action, anything more than just doing what the Constitution says. So Mitchell cleverly says, well, if they are throwing him off the ballot now, they are disabling the congressional prerogative to remove that disability. They've taken him off the ballot. And that kind of defeasible, when it's defeasible by Congress, they've taken him off the ballot. And Justice Sotomayor says, now I understand. I think she's kind of getting it. So Justice Alito then pipes up and says, well, this whole idea of self-executing is kind of a misnomer. But really, we've got a problem here. Colorado's decided this according to its procedure. What if other states decide something different? Are we going to give other states the opportunity? Is there going to be collateral estoppel, which is a judicial theory? There's going to be an argument about the effect of the Colorado statute. There's going to be a different factual record. This is kind of crazy. So then Elena Kogan pipes up and says, no, before she does that, Justice Kavanaugh comes in and talks about Griffin's case and says, Griffin's case is also relevant to trying to figure out what the original public meaning of Section 3 of the 14th Amendment is. It's by the Chief Justice of the United States a year after the 14th Amendment. That seems to me highly probative of what the meaning or understanding of that language, otherwise elusive, is. And then, of course, Mitchell picks up on this. He's speaking to the choir. Mitchell's arguing for for Trump, and he loves this turn of phrase. And then they're talking about officer. Who's an officer under? Who's an officer of? And the whole thrust of the Trump position on this is that in certain other sections of the Constitution, they use the term officer of in a way that, it really isn't the president's, because the president can commission officers of the United States. Well, he can't commission himself. So they really are hanging their hat on these other implicit ways in which it's implied that really the president isn't an officer. But it's interesting, before the Colorado Supreme Court, they were focusing more on the officer under. And the Colorado Supreme Court debunked that by finding provisions in the Constitution where officer under did, or not within the Constitution, but later action by Congress, where Congress did say the president was officer under. So come to the Supreme Court, and they're kind of switching gears. And Justice Gorsuch and Justice Sotomayor kind of took them to task for trying to slice this a little bit too narrowly. And they seem to be somewhat skeptical about it. So then during this discussion, during the midst of this officer discussion, Kavanaugh comes back and points again to Griffin's case and the 1870 Act and Section 2383. We've got an insurrection crime. Why don't we just leave it? Let somebody convict somebody. Let's forget about this. Let's just let 2383. And if Congress wants to enact a provision making a different procedure, that's fine. But why don't we just leave it there? So it says again, he's offering what we call in jurisprudential terms either a softball over the plate or a cream puff. He says it's a precedent, although not binding. But your point is then it's reinforced because Congress itself relies on that precedent in the Enforcement Act and forms the backdrop which Congress does legislate. And then, as Justice Alito says, historical practice for 155 years, and leave it Section 3, so whether it's Federalist 37 liquidation argument, it all reinforces what happened. And then a new statute, we have 2383. And to be clear, under 2383, you agree that someone could be prosecuted for insurrection and, if convicted, will be disqualified. Oh, Mr. Mitchell's loving this. He's just, eating it up. So that argument pretty much comes to a close with Justice Jackson asking a question about insurrection. One question. It takes 3 lines in the whole argument. No one pushed that button, which is kind of interesting. So then the poor Colorado attorney general gets up. Well, he's fighting an uphill battle. He already realizes he is. But Justice Kagan and Justice Alito really take him to task. And Kagan says, it sounds awfully national to me. You were talking about electors to the president. Doesn't that sound awfully national? And then she poses the question, which was kind of the shot heard around the world after the argument, saying, whether candidate A is elected or candidate B, let's say the Michigan Secretary of State is going to make the difference. We have 2 different courts, and whether candidate A is going to be elected or candidate B seems quite extraordinary, doesn't it? And I suppose this court would be saying something along the lines that the state has the power to do that. But I guess I'm asking you to go a little bit further and saying, why should that be the right rule? Why should a single state have the ability to make this determination, not only for their own citizens, but for the rest of the nation? And Mr. Murray says, because they have the power to appoint their electors as they see fit. Not really a very, very good comeback. And then Justice Alito poses the question, well, what if we have 2 different states, 2 different bodies of evidence, 2 different records, 2 different rulings on questions of admissibility, two standards of proof, two different sets of fact findings. Then what do we do? Well, first, this court would set the legal standard, and then it would decide which view of the record was correct. I think under that, if this had two cases, which view of which? What record? then he goes, keeps questioning him, and he goes and says, "Do you think it's possible that a different state court would apply things differently and say this shouldn't happen?" He says, "I'm getting a whole lot of help from you about how this would not. I'm not getting a whole lot of help from you about how this would not be an unmanageable situation." So we have the Supreme Court, pushing these buttons, going to the issue of the officer, going to the issue of self-executing, not engaging on the insurrection piece, and a lot of skepticism about what's going on. So fast forward. Courts decide cases, not issues. So the Supreme Court has to decide, was Colorado right? Was Colorado wrong in terms of what they did reason through? Or is there some reason not to credit what Colorado did? Now, in most cases, you have precedent you're dealing with. Here, the precedent is not precisely on point. Term limits versus Thornton is very helpful. Griffin's case is helpful. But, and you have Kavanaugh saying it's reasonably probative. It's an NPO. It's not a Supreme Court opinion. And Chase said Section 3 could only be made operative by legislation of Congress in the ordinary course. Specific proceedings are indispensable to ensure effective results, and these can only be provided by Congress. So you have that said, but it's not precedent. Someone's going to have to say persuasive, probative, not precedent. In most cases, judges will look at the best analytic path from a purely analytic standpoint. Judges and justices are not normally results oriented. That is, they do not say, this is what we need to do or what we have to do, and then pick a path. We follow a path wherever it leads. In some cases, though, and I think this is one, they have a concern that is bigger than the analysis. A, quote, this cannot be concern. And I think this is that case. I had another case that came to the Third Circuit and then went to the Supreme Court that I think established this principle. It was a case of Bond versus the United States. Interesting factual case. A woman was not happy when she discovered that her husband had impregnated her best friend. The woman, the wife, worked for Dow Chemical Company. She went into the chemical closet and found some pretty awful chemicals and decided to put them on the doorknobs and the car door, et cetera, of her former best friend. Attempted murder, to be prosecuted by, the district attorney? Yeah. No, that's not what happened. The U.S. attorney indicted her and convicted her of violating the Chemical Weapons Convention Implementation Act of 1998, a federal statute that was enacted pursuant to the treaty power. Now, the treaty power is pretty powerful. And if Congress passes a law pursuant to the treaty power, it's presumed to be valid. And what happened was that the chemical weapon, as defined under this law, included toxic chemicals, and they were defined very broadly. So this conviction came to our court, and my 3-judge panel said, that's what the law says. It says toxic chemical weapon. You can be prosecuted pursuant to it. And she was. We could do nothing. We could do absolutely nothing. It gets to the Supreme Court. And later, Justice Breyer commented on the process they followed. And you can imagine the 9 of them sitting around the table conferring and saying, wait a minute, are we really going to let the U.S. attorneys around the country prosecute people under the Chemical Weapons Treaty whenever they misuse toxic chemicals? So they adopted a concept of federalism and said there's certain things that are left to the states and certain things that are left to the federal government. And when it implicates federalism concerns, we really need to look at what the intent was in the statute. And rarely do we look at legislative intent, but they said this is one time when federalism concerns happen. And they said this is not what was intended. It wasn't intended to turn your standard misuse of a drug into a federal crime. But Breyer said, and it was very interesting, they sat around and they said, we can't question the treaty power. We can't do that. So we've got to find another way. And they came up with this: federalism will enable us to look behind the words of the statute. And one of the principles of construction as a judge is you cannot go to legislative intent, because there's a lot of stuff that is said in passing law that is the sausage that isn't what it ends up. In fact, in the enactment of the 14th Amendment, and this is really interesting, Reverdy Johnson, one of the senators, and this is back from the proceedings when they enacted the 14th Amendment, Section 3. Reverdy Johnson said, well, wait a minute. And this is one of the things that the Colorado, the trial court got wrong. She said, when you take something out, the president had been in Section 3, they took the president, vice president out. And the trial court said that usually means that it's gone. That's not really right. We don't know why they took it out. But they're in the proceedings. Senator Reverdy Johnson had an exchange with McKee where Reverdy Johnson says, wait a minute, why did you take out the president and vice president? Senator McKee says, I point the senator's attention to the fact that it says any office of the United States. And, Reverdy Johnson doesn't say it, but he goes, oh, okay, I guess it's covered. But, that's kind of interesting. But, do we look at that intent? Well, it is kind of helpful that at least some people thought it was still in there. But, these things are things where the courts have to sit around, and we're imagining 9 people sitting around the table trying to decide what are we going to do. And I've come up with options of what they have, and I'll tell you what, the pros and cons. So they could say, it's not right. He's not holding office. In fact, Jason Riley of the Wall Street Journal said, just wait, he'll get elected and the vice president can serve while these proceedings go on to decide whether it happened or not. So, you don't really need to decide it now. And by the way, Congress by 2/3 vote, could remove the disability. Well, of course, as a practical matter, that's not happening. So that's not what they're going to do. Didn't engage in insurrection. Well, what was insurrection at common law? Jeff Rosen had a really interesting interview with 2 law professors who were on different sides of the issue, but they were talking mostly about this insurrection issue. And one of them said the common law insurrection was 2 or more people resisting a law for a public purpose. The other one said, nope, it's a large-scale enterprise designed to overturn the government. I tried to find jury instructions under Section 2383, the insurrection crime. And that's when I will amend. I did have a law clerk research that, so I take it back. One of our interns looked for the jury instructions, and we couldn't come up with us. We came some from a Northern District of Illinois grand jury proceeding in 1894, which talked about arising against civil or political authority, the open and active opposition of a number of persons to the execution of law in the state. It's not necessary there should be bloodshed. It is necessary the rising should be in opposition to the execution of the laws. So that was a jury instruction. And then, of course, there's Insurrection Act. There are congressional acts that engage with the concept of insurrection. It was enacted in 1807, and there's a militia clause where the militia can be called forth to suppress insurrections. So there's a lot of different definitions. But the court didn't engage in that. They really didn't talk about it. And to say that, and there was an issue, well, the trial court found he engaged in insurrection. So unless that's clearly erroneous, based on the evidence before it, they can't do it. That's one of the things in the appellate courts. If there are findings of fact, unless they're clearly erroneous, we can't overturn them. Now, we can, if the definition of insurrection that they used was wrong, we could do that. But are they really going to use this to define insurrection when they really hadn't pushed that button at argument? And when insurrection is so much on the minds of everybody, are they really going to do that in this case? I think it's a long shot for them to do that. Not an officer. A lot of the academics have said, aha, that's what should be decided, not an officer. Articles have been written, just decide that, then that decides the case. The president isn't an officer, just do it. But it's kind of skeptical of that. The argument was really skeptical. And, it occurs to me that, okay, so you take the president out of Section 3. Who do you still have? You have senators, you have members of Congress. What if one of the Congress people, after Trump gets defeated again, if that were to happen, participates in the insurrection? Well, that officer's covered. Then are we going to have to decide again about Section 3 and its reach? Are we going to have this argument all over again about whether you can enforce it in the states or whether it's Section 5 and congressional action is necessary? I'm skeptical. I am skeptical that they're going to decide it based on the officer, because it doesn't get the job done. It doesn't get the complete job done. And there are a lot of academics that have said you really need to address this Section 3 issue. Does Congress have the exclusive power or not? And from the conversation among Alito, Kagan, Kavanaugh, that's a pretty interesting group to be thinking about. This is a national thing, and it's not workable. It's just not workable that states should be deciding these issues. Another thing, in the brief that Trump filed pushing on this officer piece, he referred to Chief Justice Story, some interesting cites by him about this, that the president is not an officer of the United States. And a 2010 opinion of the Supreme Court saying that officers under the United States are those who are appointed, not those who are elected. So he brought up some pretty interesting things in his brief, and they didn't talk about it, which I thought was really, really kind of curious. Another thing, one of the main articles that's been written about whether Section 3 is self-executing or not, and these Bowdy and Paulson in a U of Penn Law Review article say it's self-executing. But they wrote this huge article before the Colorado case ever came down. And they didn't really wrestle with, well, okay, states can enforce it, but what's that going to look like? So another later article that was contemporaneous really with when the Colorado court was dealing with the case, took issue with that and said, no, we really need Section 5. You really need Congress to do something. And by the way, you do very little harm by deciding the case in this way. Why? Why? Because you have 2383. You have a way. Another question posed by Justice Kagan to Trump's attorney on the officer issue is, why, can you think of why the founding fathers in this section would want to disqualify everybody, but not the president and vice president? I mean, Jefferson Davis, and wouldn't you want to disqualify? And come up with really no reason as to why you would want to disqualify. And she's pushing this button like, why would we say that? Why would we say the founding fathers really didn't want that? And to scrutinize the other language in the Constitution and say, under and of and this, it is maybe dicing it, I think, a little bit too finely. So we've got this whole idea of federalism that really is appealing to the Supreme Court. And I think when you bundle the idea of federalism and what is the national government there to do, what are the states there to do, you've got term limits versus Thornton, you've got the Grimmett case, you have 2383, you have the idea we really should decide this. You also have an issue if it isn't decided. Okay, so the states can't do this, but maybe somebody just comes into federal court. And then you have a federal court deciding this. And you have the federal court in Arizona deciding this. Does it collateral stop every other federal court? Do we really have a trial court and one circuit deciding again? I mean, it's bad enough to have a state, but even if you had a federal court, is that really okay? Why don't we just put this to bed? Why don't we say once and for all, Congress has, unless Congress does something, the procedure is not something that can be decided by the states. So we don't get into due process. We don't get into the issue of what happened in the Colorado court. We don't get into insurrection, engage in insurrection. We don't get into the idea of officer and officer under, officer of. What does that mean? It's actually fairly simple, and I think Brett Kavanaugh had it written. I really think he had it written. He was reading from his opinion during the argument and mapping it out. And that's what happens too on our courts. And I don't know whether the Supreme Court, I'm going to ask Sam Alito this. We used to have a practice on the Court of Appeals where we never discussed cases before we went on the bench. And so you'd spent your time on the bench pretty much preaching to your colleagues what your point of view was, kind of selling it to them so you could, your point of view would hold sway. We now, more often than not, will at least let each other know where we're thinking, so we can let it percolate before we get on the bench. I'm thinking the Supreme Court doesn't discuss at all, so that when Kavanaugh is saying this and Kagan's saying this and Alito is saying this, they're trying to convince the others of what we should be doing. And you didn't hear anybody else, and Gorsuch didn't say much. The only thing he was poking holes at the officer concept, saying you're like a bouncing ball with where it is in the Constitution, et cetera. Gorsuch didn't say much. The chief didn't say a whole lot. Amy Coney Barrett, not a whole lot. Sotomayor was skeptical, but then she she seemed to be turned around. But the vocal ones were the three who were pushing this button. Now, what happens in conference? There may be so many other reasons that I cannot imagine why they would decide it in another way. I'm not there. I don't know. They have their regions strategically. As I said, I have not done research. I have not explored all kinds of other things. So when it comes down and it's decided that he's not an officer, or it's decided, well, something happened in that conference room and they sent Brett Kavanaugh to the woodshed. So you just don't know. So with that, I'm pretty much done my little soliloquy here. I hope it's been interesting for you. I have so enjoyed delving into these arguments, and especially reading that Colorado Supreme Court case. What an amazing job they did. And I really just went over the holdings, but for everything they decided, they had reasoning, and they really did a terrific job. It's going to be, probably all for naught, but they certainly teed it up wonderfully. And all these arguments about insurrection and engaged in insurrection. People say, well, he hasn't been convicted, of this, and he's not an officer. And when you peel back the onion, the courts did a really good job, and there is no need for him to have. Well, now there is a need. A question, will he be indicted? Now, none of the January 6th rioters have been indicted under the insurrection clause. It's all been, obstruction of justice and other things. Because the insurrection clause is pretty, it's obviously very heavy duty, but, maybe there will be, an indictment under 2383, who knows? Because that would be a way to get someone to not be able to hold office. And it is the path.